All right, good morning, Council. My name is Judge Anthony Powell. I'll be our presiding judge today. Welcome to the Wednesday morning docket of the Kansas Court of Appeals for November 17th, 2021. We have one additional case on the docket this morning. Sitting on the panel with me this morning are two very distinguished judges. We have Judge Gordon Atchison, and we have one of our senior judges, retired district court judge, Richard Walker, with us today to hear this case. The remaining case on the docket this morning is case number 123066, Mid-Kansas Wound Specialists, PA versus Thomas A. Martin et al. And could the court have the appearances from the parties, please?
May it please the court, appellants Tom Martin and related entities appear through counsel Chris Joseph.
Mr. Joseph, I noticed that I don't have you on my list here. Have you entered an appearance on file in this case?
I should. If I don't, I'll rectify that promptly.
I have your attorney registration number. I'm sure we have it probably somewhere, but just for mine.
19778.
Thank you very much.
May it please the court, Todd Shadid on behalf of Mid-Kansas Wound Specialists and Emergency Services, PA, the appellees.
Very good. Thank you, counsel. Mr. Joseph, you're the appellant today. How much time for rebuttal? I noticed we have 20 minutes aside this morning. How much time for rebuttal would you like?
I aspire to have 8 minutes for rebuttal.
Counsel, we have read your briefs and we are familiar with the facts of the case. So, Mr. Joseph, you may proceed.
Thank you, Your Honor. There are two issues before the court. First, whether or not the appellants acquiesced and waived the right to appeal. And the second one, whether or not the sanctions imposed were criminal or civil in nature. And if so, if they were criminal, whether or not sufficient process was afforded. I want to start with the first issue. The acquiescence issue. And I'll start kind of with the standards from this court, the Ullman case, Ullman v. Richardson. It's a 2012 case. Implied waivers are disfavored according to this court. They're something that should not be done lightly. The record must clearly demonstrate that the appellant intended to abandon their rights to appeal. I don't think that exists in this case. Instead, I think the record's clear that the appellants wanted to appeal and made every effort to do so. And the best way to really kind of see that is to go through the timeline of events in this case. There's the March 6 order setting the contempt sanctions. In May 14 is the next hearing. It's an attorney fee hearing where the judge set attorney fees, which are compensatory and not necessarily punitive, at $28,000, but said they'll increase to $40,000 if not paid by a certain period of time. Defense counsel indicated that we intend to appeal and noted the grounds for appeal. Now, here's where it gets tricky. On May 20, our firm receives a check, two checks totaling $250,000. Those checks are in the record and appeal. That's volume 20, pages 8 through 11. Those go into our trust account. And that's all we end up having to work with at all. We don't have an appeal bond set yet. Later that day, we do have a hearing on the appeal bond, and the appeal bond set at a total of $300,000, $150 cash, $150 with surety. So we now have $250,000, which is inadequate to post the appeal bond, but it gets the ball rolling. What happens next is unexpected. Mr. Shadid on May 27 seeks and obtain a garnishment order that hits both accounts that have any liquidity. That's the Pershing account and the Fidelity account. Pershing and Fidelity freeze the accounts. As a result of that, we immediately file a motion requesting to quash that garnishment so that we can get some money to post the appeal bond. We're unable to do that, and on June 4th, the court denies our motion to quash that garnishment order. So we have $250,000 in trust. We have $300,000 for an appeal bond. We have sanctions around the corner. It was really the next day, June 5th, for $25,000, and it gradually increases. we're left with no choice but to pay the judgment, insisting we still want to appeal and file the notice of appeal.
Mr.
That
Joseph,
Yes, sir.
yeah, as of the hearing on June 4th, I mean, I think it's clear that your firm had in its trust account $250,000 from the Martin entities to do something with this, to deal with this contempt issue. And at that point, could you not have asked the court to set or reset the bond to $250,000 cash, which actually was more than the total amount of the sanctions imposed? And that wasn't done. There was no request made.
No, that's fair. I mean, that.
Well, and I'm trying to get the whole issue of acquiescence, and I've had it come up in other cases, is awfully squishy. I mean, there's not really a hard and fast test. It's kind of based on each case. And I'm trying to figure out, and obviously, the lawyers representing Mr. Martin, your firm, was aware of the possibility. I mean, it's discussed at that hearing. There also was no request made to stay the contempt sanctions at all. Now, I think given the tenor of where this case was, that probably was a losing effort, but it was an effort that wasn't even broached. So I guess I'm wondering, particularly with the failure to request a reset of the bond to $250,000 cash, it seems to me that at least weighs in favor of some sort of acquiescence here. And why isn't it, or is that not sufficient to tip it over the balance or over the line into acquiescence?
That's a fair thought, one which frankly didn't occur to us.
Well, I like to have fair thoughts. I mean, I'm a judge. I'm supposed to be fair. So go ahead.
I wish we had that thought. Honestly, we didn't. We have a $300,000. I mean, we had a hearing on bond. Judge was not particularly happy at us after finding out about the $400,000 settlement that had gone through.
That comes through in the cold transcript.
That
he was not happy. I get that.
Yeah. I mean, I don't. I mean, candidly, I think it would have been a wasted effort to ask for $250,000 in cash. But yeah, I mean, we could have done that. It didn't occur to us. I think we were pretty well stuck at $300,000.
Okay. Well, the other question I have is, and this is fairly loose in the record that we have, is it appears that Mr. Martin and his entities have a considerable amount of wealth. And it may not be entirely liquid. Why is it that he could not have found another $50,000 somewhere in June of whatever year this was, 19, I think, to have $300,000 for a cash bond? I mean, the record seems, again, awfully silent about that. I mean, I understand the argument that the garnishments tied up these two accounts, but given the other information in the record, he must have had other assets. And could he not have scrounged up 50,000? I mean, he sounds like somebody who might have that in the cushions of his sofa. I don't know. I mean, I don't, but he obviously had lots of money or lots of wealth. I don't know that it was like money, but
I think a lot of that wealth is farmland, other real estate assets that are difficult to liquidate. But I mean, if you look at part of the reason I went through the timeline is we get an appeal bond May 20 and June 5, we've got an escalating sanction. So we have a relatively short period of time to try to get the appeal bond. We have enough money to pay the 237, but not the appeal bond. And the answer in short is the liquid assets both were frozen. So yeah, there's some there are additional assets. They are not liquid. I had hoped that we would be able to find a surety who is willing to work with us a little bit more and come up with that $150,000 surety bond. But given the nature of the case, it couldn't happen. It just didn't happen. Nobody would take it for less than the full 150 down.
So you did investigate getting a surety then?
Oh, yeah, absolutely. In fact, yes, that was the intent. And, we don't do that too often, and we're a little surprised, given the nature of the allegations, that nobody would be willing to work with us despite that. Well, I think that's really, given the allegations and the complaint, that, they might be second in line to Mr. Shadid and others who are trying to grab onto a whole lot of money. There had been a bankruptcy petition. There had been, there's a lot of fire out there. There's a lot of issues going on. We could
Right.
not, we needed a full 300,000 plus a fee to post the appeal bond.
What was it's not in the record, but I mean, what was the status of the bankruptcy at that? I mean, was that Martin's personal bankruptcy?
It was dismissed at that point, I believe.
I'm sorry?
I believe it was dismissed at that point. So we're
Oh, okay. So there's no bankruptcy stay hanging over the proceedings on June 4th.
Correct. What we have, the only thing we have is the injunction that says you have to go to the court to get permission to do anything that's not the
Right.
ordinary course of business over 25,000, which is also another obstacle, I guess. To try to liquidate, we'd have to go to court and get permission to liquidate, and we've got a real short time frame. It just wasn't going to happen in that time frame without incurring $25,000, $50,000, $75,000, a whole lot of additional fees, and frankly, I didn't have any hope that we were going to be able to do that. I mean, it just,
Okay.
we were just
In a
stuck.
nutshell, what's the argument here for why there isn't acquiescence? I mean, I see stuff here kind of on both sides. How does the ledger shake out, and why does it shake out on your side?
The standard, the record must clearly demonstrate there was an intent to abandon the right to appeal. And we didn't. I mean, I can just tell you, we wanted to appeal. I mean,
Well,
we're saying
I mean,
we
is
wanted-
it, okay, is it sufficient then for a party to say, gee, we want to appeal, but we're going to pay the judgment? I mean, that can't be enough, is it?
Well, if we want to appeal and we can't come up with the appeal bond money, and I think the record shows we can't do it. We got $250 and we got a $300,000 appeal bond. In that time frame, we just can't do it. So we're stuck. We have to pay the judgment to avoid these additional.
Well, could you have allowed the garnishments to go forward?
It was for the 237. So it would just be the judgment paid, and then I'd be back in the position of these other case laws. Why didn't I try to stop the garnishment? The garnishment.
Well, you
wasn't-
did though. I mean, VAP is the case that deals with garnishments, and there was nothing done. I mean, you did attempt to unsuccessfully stop the garnishments. I mean, at least that's again an argument that you didn't voluntarily pay the judgment.
There was no way, short of incurring additional fines, 25,000 increments, to preserve the right to appeal, other than paying the judgment and filing a notice of appeal, all along waiving. These are criminal contempt sanctions. Process was not afforded. I mean, essentially, we would have had to pay $25,000, $50,000 more. The garnishment would have just taken the 237 a different route.
Okay.
Would
There's
there,
the fact, go ahead, Richard. Go ahead.
I guess the question is, couldn't you, and maybe the court wouldn't let you do this, pay it into the clerk of the court rather than pay it directly to the plaintiff on this?
It was pretty clear what the order was. We could have gone back, I guess, Judge Atchison is correct. We could have gone back and asked to pay $250,000 just into the court. But I think our judge was pretty clear what he wanted, and he was pretty fired up. So that probably would have been a wasted effort.
All I'm saying is that might have blunted the acquiescence argument. If you
Well-
said, we're not going to pay it directly to the plaintiff, but we'll pay it into court, and because we disagree with the decision, and then you want to order it over. I mean, that would have been a little cleaner way to oppose acquiescence.
I suppose, but that might have made the judge a little bit upset, and it would have gotten the same result. So I don't know that would have been a wise move, but yes.
Does it make a difference here that what we're dealing with is essentially an order in judgment in contempt? And the other cases that I've looked at are all basically civil money judgments at the end of a standard Chapter 60 proceeding. Does it make a difference that this is a contempt action?
It's certainly not a final, I mean, it's not an end to the case by any stretch. We still don't have.
Well, and I don't mean that. I'm not
fundamental
talking about, I mean, this is clearly a final appealable order. I'm just wondering if the fact that it is a judgment in contempt as opposed to a money judgment for a breach of contract or a tort claim makes the argument about acquiescence any different. I mean, should the law be different in that circumstance?
I think it's favorable to us because the case still goes on. We're not giving up on the merits. We're challenging a step along the way, just saying that that's criminal contempt sanction. That was too much. I really don't think we acquiesced. I mean, if we acquiesced, it's counsel's fault. We screwed up somehow. We're trying to preserve this right to appeal and we're stuck. We can't pay this darn appeal bond. We just don't have the assets to do it that are available, short of incurring Mr. Martin and his entities additional fees and fines. So we're stuck. We say just pay it. We'll raise the appeal. We know Mr. Shadid's going to say there's acquiescence, but we have to do it. We have no alternative to preserve the issue, even though we want to. And it's frankly, it's because Mr. Shadid filed those garnishments successfully, putting us in this position. I'll give him credit. He pinned us in. And I think to punish Mr. Martin and his entities because of a tactic by Mr. Shadid to file these garnishments. I mean, we're pinned in a box here. He won't release the garnishments to allow us to post the appeal bond. I mean, we're stuck, and we really had no option at this point. And credit to him for the aggressive tactic. It worked. We were stuck paying the $237 because we didn't have the assets to pay the appeal bond. He got his client some money by doing this aggressive tactic, and again, credit to him. But we didn't give up. We did not waive. We did not want to give up this right to appeal because we firmly disagreed with it, stated on the record. And with what time I have left, I would like to address that issue.
Yeah, you used your 12 minutes. So thank you.
Can I continue on the second issue, or where am I at, Judge?
You've used up your 12 minutes. If you want to use up some of your rebuttal, you're welcome to do that, but it's up to you.
Yeah, could I just use 3 more minutes to go into the second issue, the meat of the issue, as I would call it, which is whether or not those sanctions imposed were criminal or civil in nature, and whether or not due process was sufficient. So the court imposed flat, unconditional fines for past conduct. They weren't compensatory. The only thing that's compensatory was maybe the $28,000 in attorney fees. We were not given an opportunity to reduce or avoid these fines. The fines, according to Judge Dahl, were due immediately at the entry of the March 6th order. He could have imposed civil sanctions. The motion requested it was an indirect contempt citation or request. It didn't ask for any kind of criminal fines. I read it to be a civil contempt motion. He did not. With that, you typically see fines for each day of non-compliance and ability to reduce it. None of those were there. What he ended up doing is imposing these fines, which are, generally considered criminal in nature. There's no talk about proof, the standard of proof beyond a reasonable doubt. There's no discussion about whether or not the fines under consideration are considered a serious sanction, 6 figures, which would trigger a right to a jury trial. There is no charging document. There's no, if you look at the Bagwell case, which is the United States Supreme Court, it talks about the notice requirement and due process traditionally requires prior notice of both the conduct prohibited and the sanctions to be imposed. I've done criminal contempt cases, and this hearing did not have the hallmark of those kind of cases. Again, not even the appropriate standard of proof beyond a reasonable doubt. It's not being argued. It's not being discussed. This is a significant fine, which probably triggered a right to a jury trial in the 6-figure range.
Did you handle the contempt hearing or trial?
I did not. We were retained after that, so I can't speak for.
Oh, okay. All right. Yeah, I knew there were some musical chairs going on with some of the lawyers, but all right, I'll, that's fine.
So I think when we get to the meat of the appeal, whether or not it's criminal or civil and whether or not process was afforded, I think we win handily on that one. And I do agree that the judges are correct to look at the acquiescence, but again, we're stuck in a spot because of those the short time frame And because of those garnishment orders that froze the accounts, we just couldn't get the money to post the bond, which we wanted to do. Just couldn't do it. And with that, I'll reserve the rest of my time.
Very good. Thank you, counsel. Mr. Shannon, you have 20 minutes.
Thank you. May it please the court. I think I'll just dive right into the acquiescence argument and point out a couple things that I think are critical to this. You know, they claim that the accounts were frozen and they had no ability to pay, but they have presented no evidence in the record to substantiate that. None of it. In fact, the garnishment order that's in the record, at least as to the Fidelity account, limits the amount of the garnishment to I think 100 and some thousand, and the account was well above that amount. It was at 900,000. There is no response by Pershing in the record to show that they did anything with respect to an account that had over $2 million worth of assets in it.
Well,
So-
I didn't Mr. McHugh at the June 4th hearing represent that the accounts were frozen? I mean, I don't have the transcript in front of me. It seems to me he represented that.
He claimed that it was, and
Okay, is
he had
that
asked-
insufficient? Is that insufficient at that point to, you think he had to present evidence on that? Or as an officer of the court, was his representation sufficient?
It's not clear where the representation came from, whether it was from him or from his client. And if it came from his client, then I have real concerns about the accuracy of that information. Because if you read that transcript, he had asked that we release the garnishment for purposes of allowing some checks to go through. And I asked, well, tell me which account that you are writing the check from so I can specifically release that account or tell them to let that check go through so we have no problem. He would not identify the account. He wouldn't identify the check, wouldn't provide any information, and wanted a blanket release of the garnishments. So that was a red flag that it's not probably what it seems to be. And maybe he's relying on his client, who has a history in this case and in the bankruptcy case of ignoring every court order that was imposed on him. And the nature of the allegations, go ahead.
Does the fact that this is a proceeding in contempt and the judgment is a judgment in contempt, again, as opposed to a money judgment at the end of a Chapter 60 action, make any difference in how we should consider whether there was acquiescence?
No, I mean, it's a money judgment. It's a judgment, and the facts and circumstances will dictate whether there was acquiescence. The fact that
Well,
whether it was
let me suggest, I mean, if Martin didn't do anything here, he would have been subject to further contempt, correct? And in fact, the order says that, doesn't it?
he would have, if he didn't pay by a certain date, the sanction amount would go from 25 to 50 and then up from there. Yes.
And he would also, he also would have been at risk for other contempt sanctions too, wouldn't he?
Not because of that. He would have been subject to contempt for other behavior, but I think the failure to pay on that order had its built-in, incremental sanction amount. And there was nothing preventing us from garnishing it, which is what we did. So we would have tried to collect in other ways because there were assets available for that. I think that it was clear to them that they wanted to appeal, and they got a bond. They negotiated the bond. They came to court to say, we may pay the judgment and we understand what the law is on acquiescence. So they knew before they did this what the standard was. And you would think that if they knew that going in, that they would present evidence or get evidence in the record to substantiate the fact that he couldn't afford an extra $50,000, despite evidence being in the record to the contrary, that he had significant assets available. If you look at the Harbor case v. Newman, which is the Kansas Supreme Court case, we believe that's analogous to this case. And in that case, it was a specific performance judgment to turn over some real estate. They went and got a supersedis bond, but nonetheless turned over the real estate and were accused of acquiescing in the judgment. Their defense to that was they could not afford the supersedis bond. And the Supreme Court upheld the acquiescence, claiming that there was evidence in the record that showed Newman had sufficient real estate holdings that contradicted the claim that he couldn't afford to pay it. So I think it's important that they present evidence to substantiate that their accounts were frozen when the garnishment order specifically limited the amount available to garnish, which was significantly less than account value.
Okay, let me ask you this. Suppose, I mean, it's a hypothetical, but suppose they didn't pay the judgment as they did, and the garnishments were enforced. The evidence certainly suggests that that would have satisfied the judgment. I mean, there was enough in these accounts that the judgment would have been satisfied. I mean, do you agree that that's what it appears to be? Okay.
Yes.
If that had happened, would there have been acquiescence?
I don't believe so, because they would have been able to argue that they did everything they could to stop that. Now, the only counter argument to that would be, well, they had the supersedis bond available and they decided not to post it and allowed a garnishment to go through, even though they fought the garnishment. So I think it's a closer question. I would still argue they should have posted the bond, but I think they could squarely argue we tried to stop the garnishment and were unable to from the court. I would go on to add that, you know, that opposing counsel suggests that the court was not, you know, willing to accommodate requests. But if you look at the transcript, they came in and wanted an extra few days to get payment paid past the deadline, and the court granted that request. So the court let them pay post the $25,000 deadline imposed to allow them to get the checks to me. So the court was willing to make reasonable accommodations for them. I just think that from if you look at the record, you can see there were sufficient assets to post a $300,000 bond. The accounts, there's no evidence the accounts were frozen. One of the Pershing count that had over 2 million never responded to the garnishment. So it's not even clear if they even received it. They never filed an answer, and then we released it. And and if you look at the real estate holdings he had and the equity and the financial statements, this person had the ability, had he wanted, to post $300,000 in either a 150 surety, 150 cash, or full 300 cash. So I think it's clear that they acquiesced in this. They went in knowing the risks and still didn't present evidence into the record to substantiate their position that it was involuntary.
Let's assume we disagree with you on acquiescence.
Okay.
Why was the contempt proceeding in the order sufficient to satisfy due process? In other words, why is Mr. Joseph wrong in saying that these were fundamentally criminal contempt sanctions? And I recognize there's sort of a mix here, but why are at least some of them criminal contempt sanctions?
Well, if you look at the Bagwell case and the other cases that have touched on Bagwell, it makes it very clear that, I mean, well, first I'll say this: if it included a prison term, then there's really no question. If it's imprisonment, it's criminal unless the contemptor has keys to the kingdom, right? In a money sanction or a fine, then the question becomes in Bagwell whether it was a serious fine, whether it was serious. And
well,
it goes on.
Excuse me, isn't that the question for whether there's a jury trial, not a question of whether it's criminal or civil?
No, I think that's the question of whether it becomes out of the purview of the district court or the trial judge inherent power to impose sanctions, whether it's be discovery, whether it's during the pendency of case or elsewhere. I think the Bagwell court was clear that if it rises to that level, then additional due process requirements are necessary, only if it's serious and gets out of the realm of petty. And
Well,
Bagwell
I'll have to
was
go back and
limited
look
to,
at that, but all right, go ahead.
well, I'll read from the Bagwell, I think it's just what it held. The serious contempt fines imposed here were criminal and constitutionally could not be imposed only through a jury trial. Constitutionally
Right,
could
and
be
that-
imposed.
But
only
that
through
was
a
the
jury trial.
question. The question there was whether there was a right to jury trial, not whether it was criminal or civil. And I'm saying, and this one may be in some murky gray area as compared to Bagwell. I mean, Bagwell was $64 million or something.
That's
But here, okay, you're saying that these aren't criminal sanctions. This
No,
period.
you're correct. Period.
Okay.
They are not,
I mean,
because they don't. If you, the
How
way
was
I
Martin?
understand the law, go ahead.
Yeah, go ahead. I'm sorry.
The way I understand the law, and even in Bagwell, was it was a complex injunction that imposed a code of conduct on a large group of people, and it was complex fact finding, and the amount of the fine was significant that rise to the level of being serious. That's not what we have here, and I think the other Supreme Court cases that have touched on Bagwell have talked about when it gets out of the realm of being petty, then you start looking at the due process issue. What's petty, as the other court cases say, it depends on the party being sanctioned. If it's a indigent person, you can make the argument that a $1,000 fine could be punitive and criminal. But in order to have proper contempt power, you need to understand the person that's in contempt. If it is a multi-millionaire, like Mr. Martin, when the record shows the amount of wealth he has, and there's been serious violations of the court order, is a $500 fine going to coerce him to future compliance as this case progresses with a financial injunction in place? Or is something more warranted to someone of that wealth before it becomes quote unquote serious or out of the realm of petty? And in our opinion, the law is clear that you have to look at the person who's being held in contempt, not just the dollar figure, and determine whether that is serious as to that person. Now, with a prison term, it doesn't matter who the audience is.
Right. Well, yeah,
The
yes
fine,
and
I
no.
think
Isn't the classic test between civil and criminal contempt? The civil contempt is to coerce compliance going forward. So as you had said, I mean, the person committing the contempt has to hold the keys to their own freedom. And the criminal contempt is to punish for a past dereliction or violation of the order. And it seems to me that these sanctions don't have a way in which Martin can relieve himself of their effect by agreeing to comply in the future, which to me sounds like a punitive criminal sanction. Explain to me why I'm mistaken in that.
because I think they were compensatory, because the money that was paid to my client or my clients was money that he removed from his assets, one of which was taken out of the cash on hand that was supposed to be paid into court. That was dissipated, gone, just used up outside the scope of the order, which these are assets that, one, we have a judgment already against his spouse or ex-spouse that we can collect on, but that money is now being dissipated. The other is the $50,000 that he misrepresented to the court that went into his business, when in fact his ex-spouse took the money out of the bank account and is gone. She is nowhere to be found. So these were compensatory as to assets that we would have been entitled to that are now gone. In addition,
Well,
because this
you'd be entitled to them if you won a judgment in the underlying case. You're not entitled to them at the time of the contempt hearing.
we were entitled to them to be locked up under the order. We already have a judgment against Nancy Martin, And what we're waiting for, and we've already put a lien on all of her assets. Now, there's a divorce that's pending that the divorce judge is waiting to split those assets. So if those assets get split 50-50, I mean, let's just assume that it's just 50-50. Whatever goes to her, we would already have a lien on. So if those assets are dissipated or disappear, that is a harm to us because those are assets, half of which at the very least, we would have some type of interest in at that time. In addition, we would say that the significance of the fines payable to us is to ensure that as we go forward in this case, Tom Martin is aware of how serious this is and that he needs to comply with these injunctions as he goes forward, instead of the cat and mouse game that we had to engage in up until that point, which is doesn't provide information, and then we have to find out after the fact that he's spending money that he shouldn't be spending, and then we have to go to the court to say, oh, by the way, another $400,000 is gone. What are we going to do about that? There has to be something that's done to coerce him to come forward, to comply going forward. Otherwise, hey, I'll pay $500 or $1,000 every time I get caught because I'm spending $50,000 to $100,000 outside the injunction. That makes no sense for the enforcement of contempt powers of the court. That makes no sense to uphold the dignity of the court if we're limited on the amount of fines that we can put on somebody of this magnitude and of this wealth.
That's what the court chose. The next time Mr. Martin might find himself spending 30 or 60 days in the Sedgwick County Jail. I expect that might get his attention.
That would be, but that would be a criminal,
right?
A contempt that we would have to have potentially a jury trial beyond a reasonable doubt. The amount of time that that's invested in first finding out the violation after the fact, since he doesn't want to share information, and then setting the time up. This took a year to do a contempt trial. I mean, that's how this case has gone. And I know that opposing counsel wasn't involved in any of that. They came in after the fact. This case has been littered with non-compliance, delays. The same with the bankruptcy court. If you've seen the transcript, even the judge commented. The bankruptcy judge, in dismissing the bankruptcy, made the same comments about disregarding court orders, has no interest in complying with what the court tells him to do. So this is the person that we're dealing with, and is of significant wealth that has snubbed his nose to both my clients and this court. And the question becomes, is a six-figure fine to someone who's worth $20 million serious, or is it still in the realm of petty as to him? And that's, I think, the issue that this court needs to look at before it decides it's automatically criminal because it's a significant amount. There is, we've cited in our brief, and I don't need to bring it up here unless the court wants, but there are a couple Supreme Court cases that talk about this very issue when it becomes petty or not. And it's key to the person that's been fined. They could find that a $500 fine to someone may be serious, but it may not be a $10,000 fine. It may not be serious to a regular business. And so the amount of the fine in relationship to the party who has to pay it determines how serious it is and whether additional constitutional protections are required. And if you add Bagwell to the mix, then you also have to look at the complexity of the injunction or the complexity of the fact finding to find contempt, and then determine whether you need to remove all elements of bias because of that complexity. We don't have any of that here. This was straightforward. This wasn't a gotcha kind of scenario. This was over a period of time, several opportunities to bring himself in compliance, 3 separate hearings over a year's period of time. They made 0 objections to any of the process. He testified freely. They didn't ask for a jury trial. In fact, in Bagwell, they did ask for a jury trial and it was denied. They didn't ask for anything. They went along with this knowing that they were going to face some heavy fines because they were spending money and putting it in their pocket against the court order and defying court orders. Not one. I think there was 20 violations of court orders over a period of time. So the question becomes, can a court have the ability to impose compensatory fines that would coerce future compliance in a case that is still ongoing, where the preservation of assets is a key element of the case. And we already have a judgment against one of the parties in this case for over $11 million for stealing millions of dollars from my clients. And we're still trying to fight on the civil side with respect to Tom Martin, but we can't get there because we're dealing with this and trying to capture all the assets and delays and contempt. So I think to conclude that they did acquiesce, that they clearly had a path to showing that they didn't. They don't present any evidence other than just making a representation to the court. Well, the accounts were frozen, even though there are documents in the record that would contradict that. And if I were them, or I think the court, it would be, we think we need more than just a representation when there's actually evidence in the record that would contradict the representations being made. And it's not to say that the attorneys were making false representations. I'm not saying that. I'm saying it's very well likely that the representations were being made because they were made to them by their client. And that's the problem that I would have with the lack of evidence. We also think that the fines were not civil or not criminal in nature, and the due process was satisfied considering the wealth of the Tom Martin and the nature and willfulness of the contempt. If the court has any questions, I don't know where I'm at on time, but I'm not going to take up any more. So appreciate it.
Time, Mr. Shedden, thank you very much. Any questions from the panel? Seeing none. Mr. Joseph, you have 5 minutes for a rebuttal.
Thank you. Let me start with the contempt issue. There were no I can't speak for prior counsel, but it made sense to me that there were no objections to the scope or to the hearing because, frankly, it appeared by all indications that they're participating in a civil contempt hearing. There's no indication, there's no use of the word proof beyond a reasonable doubt. Jury trial or not, you still have to have proof beyond a reasonable doubt to set a fine that is flat, fixed, and there's no keys to the castle to reduce or mitigate. That's what makes it criminal. And again, Mr. Shadid makes a lot of statements about, it's compensatory, but that again, it assumes liability, none of which to this day have been proven, despite our attempts to get this case moving along. It is still stuck, as Mr. Shadid acknowledges. We haven't got it. I've had summary judgment on a brief for like a year and a half, and the divorce is sitting in the way. I want to talk a little bit more about acquiescence. Should have presented evidence that the accounts were frozen. Look back at the timeline. On June 4, we are asking the court to set aside the garnishment that we don't think is proper because, heck, we still have time to pay. We're going to go get that additional money as soon as that garnishment order is removed. We're thinking we're going to have relief. We're going to get $50,000 that day and then go post the surety bond. The court says no, surprisingly, and we're stuck. So we've got 1 day to avoid some additional sanctions. The reason judge granted us some relief for a few days was for fear for us, I think. We've got a trust fund issue, right? He's garnished the account. We've got 2 checks. They've been posted to our trust account, but we're concerned that, this may get swept back out because of the garnishment order. That's why we're seeking relief. And I think the judge acknowledged we had some concerns if suddenly we go $250,000 in the hole in our firm trust account, that's a big problem. We didn't present evidence. We made a representation to the court that accounts were frozen. They were frozen. We couldn't get the money out of them. Between June 4th, when we're expecting to get relief, and June 5th, when that additional sanction comes in, I don't know what forum we would have had to present that evidence. I also don't know sure how we would present that evidence. These are out-of-state entities other than just representing to the court. It's true. You'll notice it's not surprising, though, on page 3 of our reply brief, we're citing authority in other cases. It's pretty common. It's a standard practice that brokerage accounts are frozen upon receipt of a garnishment account. And these were brokerage accounts. The court could have taken judicial notice they were frozen. It wasn't contested. The other thought of we would not have acquiesced if we let the garnishment go through. A thought that occurred to me when Mr. Shadid was speaking is I suppose we could have let it gone through, but we would have incurred that additional penalty, right? That becomes due on June 5th, and the garnishment had not gone through. So I think we would have been hurting our client. We were stuck. We were stuck because the court would not lift the garnishments. The accounts were frozen. There's literally nothing that we could have done. I mean, Monday morning quarterbacking it, I suppose Judge Atkinson's decision or suggestion would have made a lot of sense that we could have asked for $250. We had 1 day to think that through. I just, frankly, I don't think we would have gotten it. We only had 1 day before that additional $25,000 fine went through. On June 4, we thought we were going to get some relief and the court was going to say, hey, Mr. Shadid, those garnishments were premature and didn't comply with statute. We were surprised he did not. That left us 24 hours to avoid a $25,000 sanction. The reality is, most of Mr. Shadid's complaints suggesting acquiescence goes to legal strategy. We're having discussions internally. We're trying to figure out how to post that appeal bond, and we just ultimately can't. We don't want to give up our right to appeal, but we also don't want to put our client in a worse position, incurring that additional $25,000 fine and graduating sanctions. So we're left paying the judgment under protest, if you will, saying, hey, we want to appeal this, but we can't do anything else. So we did not acquiesce. I will go back to the criminal versus civil. I mean, I think these are pretty clearly criminal. Whether or not they triggered a jury trial right, I don't know. I think they did, but that's something that was never explored. We never discussed that down below. These were 6-figure fines. I think that would trigger a right to a jury trial. Nonetheless, even if it didn't, we were right. We had a right to findings for proof beyond a reasonable doubt, certain kind of notice, things that are even without a jury trial in a criminal case, we did not get. None of that's on the record below. The sanctions that are criminal in nature have to be reversed and sent back down. If those trappings of due process are later applied, I suppose we can redo those. But at the moment, you have a criminal contempt sanction without the due process required jury trial or not for a criminal sanction. I stand for any questions.
Seeing none, thank you very much, counsel. We appreciate your excellent arguments today. We will take this matter under advisement and we'll issue opinion as soon as we're able. Thank you all.
Thank you.
Thank you.